think that's as loud as it can go. Does that sound good? Okay, perfect. Thank you.
There's a little bit of the buzz, but it's not bad.
Yeah, I wish I could stop that.
It's fine.
Okay.
Yeah, it's fine.
Okay, bye. Okay, we're good.
May I begin? Okay. Good morning. My name is Lawton Hawkins. I'm a lawyer with the Coca-Cola Company, and I also do some legal work for the Coca-Cola Foundation, which is our nonprofit arm. I'm going to be speaking today about background checks and liability waivers, something that may be of interest to a number of organizations. Before I begin, I wanted to tell a little bit about the mission of Pro Bono Partnership. If you have a copy of the slides, the PowerPoint that was distributed, you can see that it's set forth on slide 2. The mission is to provide free legal assistance to community-based nonprofits that serve low-income or disadvantaged individuals. Pro Bono Partnership matches eligible organizations with volunteer lawyers from leading law firms and corporations in the hope that they can assist nonprofits with their business law needs. There's certain eligibility requirements if you would like to avail yourself of Pro Bono Partnership services. First, you must be a 501c3 nonprofit organization. You must be located in or serve the greater Atlanta area. You must serve low-income or disadvantaged individuals, and you must be unable to afford legal services. More information can be found on their website, www.pbpatl.org. Pro Bono Partnership hosts a number of webinars on legal topics to nonprofits. This is one of them. If you'd like to view a list of other webinars or workshops, please check the website. And then finally, a few more things before we begin. I'd like to thank the Georgia Legal Services Program for hosting this webinar. And I don't know if Emily McClarty will ever be viewing this, but she was an intern with Pro Bono Partnership who provided a lot of very useful and, in fact, invaluable legal research assistance on this. So Emily, if you listen to this and you hear it, thank you very much. You did a great job. Okay, let's begin. If you can turn to page 4 in your PowerPoint, we'll start with that. I wanted to start out with a little bit of a cautionary tale and tell you what can happen if, as an organization, you don't conduct the appropriate background checks. And this is an actual case. I can't remember the year it was. Okay, 2006. And in 2006, there was a Little League baseball organization had an operating manual that suggested establishing procedures for background checks. It didn't require it. It just simply said to the local Little League affiliates, it would probably be a good idea to do background checks. A local Little League organization took on a volunteer umpire without doing the check. The umpire then, at some point, proceeded to molest one of the players. Naturally, the parents had assumed that the umpire had gone through a background check, and so they proceeded to sue Little League, the parent organization. The basis of the suit was negligent supervision of the local Little League and the failure to conduct the required background check itself. As it turns out in this instance, Little League, again, the parent organization, if you will, was not held liable for the umpire's acts on the ground that it was a bit too attenuated. The relationship between what the Little League parent organization did and what the umpires did was a bit too attenuated, and therefore the acts of the parent Little League corporation, or parent Little League organization, I should say, were held not to be the proximate cause of the boys' injuries. If there are any lawyers around here, you can maybe appreciate the term proximate cause, but all it simply means is if something is a proximate cause of an injury, it means there's a legal basis for saying that the negligent act and the injuries complained about can be linked in a way that the law will recognize. So, in any event, in this case, as it turns out, there was no liability. But I do think it serves as a cautionary tale for people who are involved with nonprofits, especially for the nonprofits involving children. Certainly, the defense of the lawsuit was very expensive. It was terrible for the reputation, both of Little League broadly and also for the local Little League organization. It was a big distraction from the work that the Little League was trying to do, and it was a bad situation for everyone. So this, I think, serves as a good cautionary tale, even though in this particular instance the defendant was not found legally liable. If you'll turn to page 6, I've got a few statistics here that were taken from a choice point entitled "A Brief on the Importance of Background Screening for Nonprofits." These were some rather sobering statistics. Every 6 minutes, according to this source, a convicted criminal attempts to work with a nonprofit. Every 43 minutes, a sex offender tries to work with a nonprofit for youth. And 5 out of 100 applicants, in fact, had a criminal record. I hope that causes you as much concern as it did me when I read those statistics, and helps cement in your mind the importance of conducting these background checks. So let's go into a little bit more detail about the checks themselves. I'm on page 8 of the PowerPoint. Okay, why should you conduct a background check? One reason is because of negligent hiring lawsuits. That's the sort of thing that was implicated in the Little League case we discussed a few moments ago. If an employee's actions, and I should say here an employee or a volunteer's actions, we'll talk about that a bit in more detail shortly. If an employee's actions hurt someone, the organization itself may be held liable. A bad hiring decision can ruin the organization's reputation and can also ruin the career of the individual making the hiring decision. Not to mention the legal expenses and the possible actual damages assessed by a court. Another reason is that Georgia law, in fact, requires criminal background checks for anyone who works with children, the elderly, mentally ill, etc. And even if it's not required by law because the organization that you work for happens to be serving a slightly different population, it still is very good practice. And I encourage all of you to conduct these background checks, whether the law requires it, strictly speaking, or not. Okay, so what is a background check? A background check is a way to look into a person's education, their employment history, criminal history, if any, certain other personal information, financial information, driving history, which can be very important naturally if you're talking about someone who has the obligations to drive a bus or to transport some of your participants from one place to another, etc. And they usually go back 7 years. So, on whom should you conduct a background check? Naturally, you should be doing this for prospective employees. Also, as alluded to just a moment ago, you should also do this for prospective volunteers. I got this very, I thought, helpful quote from Emily, and unfortunately I don't recall the source, but I thought it really captured the issue around volunteers. Companies and organizations are often so happy to have volunteers that they assume a volunteer spirit of public service and dedication to community denote someone who couldn't possibly have a blemish in their background. That is not something you should rely upon. If you have someone who has the potential to do harm to your participants, especially participants who are disadvantaged, minors, elderly, etc., it is incumbent upon you to do a background check whether or not this person provides their services for free or for a salary. Okay. When should you conduct these background checks? First, of course, is that they should be done prior to extending employment or accepting the initial volunteer services. In addition to that, you may feel it's appropriate to conduct these on a periodic basis. For example, let's suppose that the role of the person changes substantially so that they're taking on greater responsibility, they have greater contact with your participants, maybe they're involved, maybe they have to take on the job for driving the kids around, and you never did the driving piece of the background check, for example. In any event, under certain circumstances, you might want to periodically update the background check. And of course, if there's a specific concern, if something has happened to give you pause about this person, you might want to take that opportunity to conduct a second check. Now, it's important, however, that your waivers indicate, I think we'll talk about waivers in just a moment, but when you get a background check, you have to get a waiver that it says, where the person says it's okay to conduct these background checks. But in any event, when you get these waivers, you should indicate that the background checks may be ongoing throughout the employment, so you don't have a problem later that, oh, well, you said you were going to conduct this one background check, and then you proceeded to do it on a continual basis. I'm all the way on to slide 12. There may be questions, I don't know, but I'm just going to pause and ask the folks who are helping me with the webinar if there's anything we need to respond to right now.
There aren't questions right now.
No questions? Is that because you're dozed off, or am I being that lucid in my explanations? Please feel free to include any questions as they occur to you. Okay, I'm on page 12. We're going to talk for a moment about the Federal Credit and Reporting Act, the FCPA. Strictly speaking, the FCPA only deals with background checks that are conducted by credit reporting agencies. But again, I talked about this a little bit earlier when I was talking about whether background checks were required under Georgia law, etc. And I said then that even if, based upon the population you serve, a background check is not, strictly speaking, legally required, it's still prudent and the appropriate thing to do. Well, I feel the same way about complying with the terms of the FCPA, even if the particular background check you're conducting isn't done through a credit agency. So it may not be legally required in all instances, but I think you should act as if it were, because it does, in a sense, codify best practice. Anyway, let's talk about what those requirements are. First, as I mentioned just a moment ago, prior to conducting a background check, you have to get the written authorization of the party who you're going to be checking. The authorization should be clear and unambiguous, and there actually is a specific legal requirement that says this has to be on its own piece of paper. I mean, what they don't want is for the waiver to be sort of in fine print at the bottom of a document that's really intended to serve some other purpose. The point is, you want to make sure that you call the fact that you're going to be doing this background check to the attention of the person who you're going to be checking, so that there's not some misunderstanding. And of course, I think we would all agree that's good practice in all instances. Okay. If you do a background check with a credit reporting agency, this will be easy. You don't really need to memorize this or anything, because it'll be, when you deal with them, they'll just require that you do this. They'll require that you certify to them that you have complied with the disclosure and written authorization piece that I just spoke about a moment ago. That you will comply with the law regarding adverse actions. We'll talk about that in just a moment. And that you're not going to use this information that you receive from them in violation of any law.
Can I interrupt?
Sure.
When viewer asks where's the best place to get a background check done, the sheriff's office or a service like Choice Point?
You know, there are lots of different possibilities. As I say, some of the credit reporting agencies can assist. The Georgia Bureau of Investigation has a website you can check on. You mentioned the sheriff's agency. I can't right now say precisely which one would be the best, but just be advised there are numerous options available to you. Okay, this next slide, I'm on slide 14, talks about an investigative consumer report. This may not really be necessary, and I didn't do a lot of research around this and don't plan on talking about it in any detail. This is relevant for when you engage in a bit more thorough background check, where you actually go and you talk to neighbors and friends, and you conduct a very thorough background check. If you are going to be doing this, there is a separate disclosure that's required under the whoops, I think I have this. Anyway, there's a separate requirement for disclosure, and you can look into that in the event that you are required for whatever reason to conduct a more thorough check than would be the ordinary course. Okay, I'm on slide 15. What happens if there's bad news? What happens if you do this check and you find out that there is a significant problem, perhaps a criminal record or something like that? Before any, what in the law refers to an adverse action. What they really mean by adverse action is it basically means a decision not to hire this person. So before you make a decision that you're not going to hire someone based upon the background check, you have to give the applicant a pre-adverse action disclosure. Essentially, this is a copy of the report and an explanation of the consumer's rights. When I say the consumer, I really mean the applicant here. And then you need to wait a reasonable time to allow the applicant to challenge the information itself. This 5 business days is itself is not required by a law, but generally 5 business days is considered to be a reasonable amount of time. So essentially, what you don't want to do is get the background check, find out there's a problem, then just fail to hire the person and never tell them anything about it. Now then you might have a problem, because it's possible that there was a mistake made, and you want to make sure you give the person a right to rectify that mistake. Did someone have a question? Were you waving your hand? No? Okay, great. All right. I'm on page 16. So, you found out that the applicant has some problems that make it inappropriate for you to hire him or her. You let them know about it. You wait a few days to give them the opportunity to correct any problems. Those problems are not resolved, and you now are in a position to take this adverse action. Now, at that point, you have to give them an adverse action notice, and it contains the name, address, phone number, etc. of the screening company that you use. A statement that the screening company itself is not the one making the decision about whether to hire them or not, but that your organization is making that decision. And a notice that the individual has a right to dispute the information in the report. Anyway, if you go on, I'm on page 17. I've got a nice website here that I would direct your attention to if you'd like to have more information about how the Federal Trade Commission interprets this investigative consumer report and some other topics under the Federal Credit Reporting Act. Check out that website, and I think that you'll find that it's quite user-friendly, and it answers a lot of the detailed questions that you might have. All right, so that takes care of my presentation on background checks. Just to summarize, I strongly recommend and urge you to conduct background checks on prospective employees and volunteers prior to hiring them or accepting their services. And I strongly suggest that you follow the rules of the Federal Credit Reporting Act, whether or not you are using the services of a credit reporting agency, both because it's good practice and also, frankly, because it's easier to have one process in place than two. Things won't fall through the cracks that way, so I would suggest that. Okay, I'm going to talk now about liability waivers. Essentially what a liability waiver is, it's a document that you might give to your participants and maybe their parents if the participant's a minor that says, I, participant, I waive my right to bring a lawsuit against Pro Bono Inc. For any damages that I might suffer as a result of my participation in their program. The idea is that I, as a participant, am assuming the risk that something bad might happen. I agree to assume that risk, and therefore I relieve, I'll call them Pro Bono Inc., whatever that charity or nonprofit organization might be, I relieve them of responsibility. Okay. So the one main purpose of it is that it can help protect organizations like yours from lawsuits. And secondly, it can serve to set the expectations of the participants. They understand that they have responsibilities here and that if something goes wrong, they can't immediately just blame your organization for anything untoward that might happen to them. Let's talk about how you might go about drafting and presenting your participants with a waiver. When I originally prepared this presentation, I thought I was going to be speaking more to lawyers than to organizations. And so I've got a little bit of detail as we go through here about how broadly to draft these, et cetera, and I've kind of skimmed through that in this presentation. But the basic idea is you want to draft them as broadly as possible to cover any possible contingency. But there's a tension there, because if you draw them too broadly in a way that's unreasonable, then there is the risk that a court will say, wait a minute, this waiver is not enforceable, it's not reasonable, so you can get yourself in a little bit of trouble by drafting these too broadly. And we'll talk a bit about the practical implications of that in just a moment. The second point, and I think I alluded to this just a moment ago, is that in the event that your participant is a minor, you should certainly require that the waiver also be signed by the child's parents in order to make it enforceable. And then prudence dictates that the waiver be clear, conspicuous, unambiguous. Don't write it in small type. Don't try to save one piece of paper because you don't want to go over on the next piece of paper on something and thereby put it in 8-point type. That's definitely a no-no. So make it clear, make it conspicuous. If you want to put something in bold somewhere, all that is to your benefit down the road, because one of the best ways to attack the enforceability of a waiver is to say, oh, well, my client didn't realize what he was signing. It was way down here in small print on the side, or it was not something that a reasonable person would have even noticed. Well, you can avoid that sort of thing by making sure that your waivers are clear, conspicuous, unambiguous, etc. And we have some examples of possible waivers, though I should note those examples are simply examples. They should, when I give those out, those are not meant to be used willy-nilly. If you do choose to have a waiver done for your organization, please contact Pro Bono Partnership. Okay. So, are waivers enforceable? Well, the good news is that in Georgia, generally speaking, courts will enforce written waivers if they cover the matter at issue. Georgia courts tend to say, well, he agreed to waive his rights here. Fine, he waived them. And generally, no consideration is required for a waiver. If there are any lawyers in the group, you can think back nostalgically about first-year contracts class and the months that you spent figuring out what consideration was and what the various elements of consideration was, etc. If you are a nonprofit organization, don't worry about it. You can just skip that bullet point. Okay, I'm on slide 21 now. And this slide is actually pretty important, and in fact it's something I learned about in the process of doing this, the preparation for this presentation. So this presentation has been very useful for me. I hope it's also useful for you. The Georgia Code section 13.8.2 invalidates contractual provisions by which a party, in this case let's think about it, that party as being a program participant, indemnifies another party, in this case let's think of it as the pro bono organization, for bodily injury or property damage caused solely by the other parties, again the pro bono organization in this case, by such parties' sole negligence. What indemnification means basically is, well, let's go to the example. That might make it easier. Let's move to page 22. If you see it in an actual case, maybe it'll become clear, and I can explain some of these terms as we walk through it. Okay, Pro Bono Inc. They hire a bus driver without doing the appropriate background check. The driver, as it turns out, has a record of drunk driving. It has an accident. It injures some third-party plaintiff, just someone in another car. Now that third-party plaintiff wants to sue someone. Well, who do they sue? They sue the pro bono organization on the grounds that they were negligent in their hiring practices or whatever. Now, in that instance, all of the participants may have signed a waiver that says, we, all of us collectively, all these various participants, will indemnify Pro Bono Inc. for any damages that Pro Bono Inc. Suffer, any damages that Pro Bono has to pay out as a result of providing these services. And in this case, indemnifying basically means we'll pay you back. So if this indemnification were enforceable, the gist of it would be Pro Bono has to defend against the lawsuit from this third party. Pro Bono pays a bunch of money, and then these participants are then required to reimburse Pro Bono for the cost that Pro Bono had to expend in order to either settle or pay out an adverse verdict in the lawsuit. Well, I don't know about you, but that sounds a little unreasonable to me. And that's what the courts have held. And that's what the law that I referred to just a moment ago also addresses. Now, right now we're talking about indemnification. There's the other notion of just waiver. A waiver situation is not all that different, but it's a slight variation. In a waiver situation, you might say, okay, the bus driver has an accident, and one of the children, hits their mouth up against the seat in the bus and loses a bunch of teeth or something, and they want to bring a lawsuit against Pro Bono Inc. on the same grounds. Well, the question is, this isn't really indemnification, it's a slightly different thing. Well, would the waiver be enforceable in this instance? I'm on page 23, in which I talk a little bit about this case. I'm not going to talk about this with you folks in any detail, but the gist of it is that the Georgia Supreme Court has essentially applied this statute to waivers as well, which is probably a matter of greater concern even than indemnification. So I'm now on page 24 of the slides. The question then becomes, is a waiver enforceable in that instance? Well, if the accident was the result of the sole negligence of Pro Bono Inc., maybe the waiver may not be enforceable. So in that instance, if the child loses a number of teeth because of poor driving by a bus driver who, let's say he was drunk and you had never done the background check, then that waiver will probably not be held to be enforceable. The upshot of that is that the child or their parents can bring a lawsuit against you. Okay. What do you do in that instance? Well, the first thing to do is don't let it happen from the outset. Do the background checks that I talked about earlier, and that will insulate you from a number of potential problems. The second, of course, is to make sure that you have appropriate insurance coverage so that in the unlikely and unfortunate event that you are held liable in a situation like that, you have some ability to go after an insurance company to help offset your losses. The third thing you can do is provide specifically in your waiver for let's call it an exception. And the reason I think it's important to put this in is that it's possible that if you draft your waiver too broadly, a court will say the whole thing's unenforceable, and then you're stuck with nothing. Now, I can't tell you that this is the case because there's been no actual legal decision that determines this definitively in Georgia, but there's a risk of this. So, the language that I would suggest is that after you put in the everything but the kitchen sink waiver clause, you put a proviso in to the effect that, provided, however, that this limitation of liability shall not apply to third-party claims for personal injury or property damage to the extent caused by or resulting from the sole negligence of your organization. That may go a long way to enhance the enforceability of your waiver. I should say that you can never be 100% sure, even in this instance, that the waivers will be enforceable. And for crying out loud, you don't want to rely on a waiver in any event. This brings us back to the start of the presentation. If you take anything away from this presentation, it will be that while a waiver is good, and that helps perhaps eliminate your exposure in the event of a problem, the best solution is to conduct the necessary background checks and do whatever it is required to ensure that the problem doesn't arise in the first place. Thank you very much for your time today. If you'd like more information about this topic or about the services of Pro Bono Partnership of Atlanta, you can contact us at the information on page 26 of the presentation. Are there any questions?
Yeah, there is one. It says, when we talk about problems caused by drivers, I wonder whether we should be running separate driving record checks over and above the basic criminal background checks for our volunteers who will be driving. LexisNexis offers this for an additional $6 per check, I believe. At the present, we only obtain a copy of the driver's license and insurance card, and we ask references about their volunteers' driving safety.
Well, whoever made that point is exactly right. Especially if you're dealing in situations where folks driving your kids around. I mean, there might be. I did a little work recently for an organization it's a great organization actually, involved in soccer, helping use soccer for children both for health reasons and for character building and all that sort of stuff. Well, there's a lot of driving kids around from to and from practice and games, and all of these children, of course, will have their own means of transportation, or in some instances, organizations that don't typically drive folks around may have activities in the afternoons and early evenings, and particularly in the wintertime. Some of these kids, you don't necessarily want to have them walk home, particularly if it's through a bad neighborhood, and so sometimes volunteers who might not normally be thought of as folks who do a lot of driving might be called upon to do that sort of stuff on an ad hoc basis, and it would really behoove you all to conduct those separate background checks around driving, if there's going to be any like that.
Another question is, I've heard we should run background checks every year to keep things up to date. Is that general practice?
I can tell you it's not legally required. I don't think it would be a bad idea, but I don't know if it's really necessary. You sort of have to use your judgment on something like that. The instances that I alluded to earlier as being triggers for the need for background checks were really more around change of responsibilities, specific concerns you might have about this person, things like that. This is not a legal requirement, but as long as you provide clearly in the waiver that background checks will be ongoing, it won't be a legal problem either if you choose to do it on an annual basis.
And that's all we have.
Great. Thank you very much for your time.